We're now left in a situation where we have to discuss at least the possibility with potential clients. And as you're thinking about these decisions, you have to think at least about the possibility that between the moment you disclose and the moment that there's a declination, something goes wrong outside of your control in terms of your perception, the perception of your company with the Department of Justice, with this administration, that could lead to an adverse action.
Hello, everyone. This is Tom Fox, back for another episode with my good friend and colleague, Mike DeBernardis. Mike, welcome back.
Thanks, Tom. Happy to be back.
Mike, we had some interesting news a couple of weeks ago that I really wanted to see if I could explore with you, and that was the criminal indictment of Smartmatic. Now, there was an ongoing criminal indictment of senior executives of that company for alleged violations of the Foreign Corrupt Practices Act. But this is the company itself was indicted. And this was the first criminal indictment against a company. Matt Kelly and I tried to look back to see when a company had been criminally indicted. It's been 15 years or so. So the companies, while having paid large civil fines, are not typically criminally indicted. But the thing that worries me, Mike, or worried me when this came out was, what does this do to this administration's proposed or documented thoughts on self-disclosure? You and I had the opportunity to visit about the new policy on self-disclosure, and we felt that the weight of benefit was getting close to perhaps the risk where you could discuss it. Well, what do we do with this now?
Yeah, I think we should just highlight to start how extraordinary this indictment is. 15 years ago, and I'd have to look back at the records and see the context of even that indictment 15 years ago. If you listen to Smartmatic's side of the story here, they were actively cooperating with the DOJ investigation when this decision was made. That fact in and of itself is extraordinary. But to your point, in our past conversations, we've talked about this balancing. And when you're having conversations about potential self-disclosure, especially on the business side, they want to know what's the potential penalty what's the potential outcome if we self-disclose? What is the potential outcome if we don't self-disclose and the conduct is discovered? And then what's the likelihood that this conduct gets discovered in that context? And any level of predictability in the system is helpful in that conversation. And that's why I think you praised, many people in the industry who praised the most recent revisions to the CEP that really tried to inject a little bit more certainty and predictability into the system. You're never going to have complete certainty in these circumstances, but at least try to put a little bit more certainty into the system. What this does to me, this decision, which was unexpected, erratic, unpredictable, is it now muddies those waters. We're now left in a situation where you have to discuss at least the possibility with potential client. And as you're thinking about these decisions, you have to think at least about the possibility that between the moment you disclose and the moment that there's a declination, something goes wrong outside of your control in terms of your perception, the perception of your company with the Department of Justice, with this administration, that could lead to an adverse action. And that will absolutely muddy the waters. And that, to be honest with you, the toughest thing is that is the hardest thing to predict. It is nearly impossible to predict. You also have to think, as I know you and I have discussed offline, about the possibility now of is there going to be additional conditions to my cooperation and my effort to get a declination? Are there going to be things that are really unexpected added to this that have a more political flair? Because it's impossible to separate the politics from the charging decision in this case.
It just made me think, Mike, we've obviously seen this administration have a sea change in the area of the United States government taking an interest, as in a stock interest or equity interest in companies, or having a board of directors seat. And I don't think we've explored that in depth on a podcast, but it just strikes me that given we've kind of broken that fourth wall, that could be one of the conditions.
Yeah, which is really kind of scary from our capitalist system to think about. One of the criticism often lobbed at systems like the communist-esque system in China with all the state ownership of various commercial organizations is that it taints the rule of law as well, right? You're thinking about a lawsuit against a company that's owned by the state. How is that going to be assessed? You're thinking about state-owned entities that are engaging in misconduct within China. How is that going to be assessed? And we have not only the possibility that a condition might be, hey, instead of a fine, we're gonna take a portion of your company. Once the government does own portions of companies, what's to stop? We're extrapolating here, but what's to stop them from taking aggressive enforcement against those companies' competitors to further distort the competitive market?
Mike, for those who may not know who Smartmatic is, they are a voting system company who has civil litigation against Fox News, the Wall Street Journal, and perhaps others for defamation and allegations around the 2020 election. And those are clearly antithetical to the interest of those in this administration. So that's what leads us to, or at least perhaps you to saying this is politically charged. But and then to your point on what additional conditions. So if you're sitting across from the DOJ and you follow the guidance on declinations, you've made that self-disclosure, you think you've met the conditions, and the DOJ says, we agree, we are going to grant you a declination. What does the company get? We all see the letters that the DOJ issues, but does that letter give you any protection from anything further?
After the letter is sent? That's an excellent question. I don't know that we've ever been presented with that scenario in real time. I believe the answer is not entirely, right? If circumstances changed post that letter and the government decided to indict it, I'm almost positive they'd be able to find some avenue to do so. Now, obviously, that would crater to a large extent any attempt to encourage any company to self-disclose any conduct ever again. It would be a very market-moving decision in that sense, right? All the efforts over the last 20 years to encourage companies to self-disclose would go up in a puff of smoke. But I think that if any enterprising prosecutor who had the blessing of management of the Department of Justice could probably find an angle to push aside that piece of paper and move forward with a prosecution nonetheless.
Mike, how do you approach a client to have this conversation? You say, I have to raise this to you. This is going to be a difficult subject. I personally, or the firm feels like it's very little or low risk, but I do have to raise it. How do you even begin that conversation and then have a dialogue that maybe you and I are having with the client?
Yeah, I think circumstances are going to vary. And there's probably some clients in some industries where this is going to be a more serious and detailed discussion than others. I think there's probably some clients that I have that if they were in this position of having to self-disclose are either under the radar enough or not really in a industry or at a level that is going to likely draw the attention of senior members of the Department of Justice or the administration or the political faction. But for those companies where this really does present itself as a risk, I think we would talk about it in the same way we talk, very matter of fact, in the same way we talk about the likelihood of this conduct being discovered absent a self-disclosure, the potential penalties for each, and then the likelihood of it's hard to pin down, but the likelihood of some sort of political influence in the ultimate decision on your declination. I think you have to just treat it as another consideration. I think in most cases, the good news is in most cases, the risk is going to be low. I started by saying that this indictment was extraordinary. I meant that as we should all be paying attention to it because it's extraordinary, but also because it's extremely rare. So I am personally hesitant to jump to too many conclusions, to completely change the way I go about my business based on this, but it's something that as an attorney and trying to provide advice to a client, we at least have to raise.
So really, you can almost take a dispassionate view that this is a risk. It's a new risk, and I need to discuss this risk with you. I have a view on it, but I need to present it to you, sort of analysis.
That's exactly right. That's better said than I did. It's a risk, and it's one that's frankly hard to right now to quantify, but it's one that we have to sort of at least consider as part of this decision.
So I think the words you used were politically charged indictment, and I want to pick up on that and maybe go in a little bit different direction, because I come out of the energy industry, and in the energy industry, it's the Wild West, it's everything goes and everything in between. And when that comes to litigation, when that comes to whistleblowing on your competitor, or a wide variety of other things. And I guess being the cynic that I am, kind of coming out of where I did, the immediate thought I had was, what if a business that makes a donation to this administration and has an audience with the Department of Justice raises an issue? And the Department of Justice says, we agree, we'll do something. How can you even begin to assess what a competitor might do to you? Certainly you're not going to have good intelligence or good information to have that discussion. And once again, do you raise it with a client that says this is a potential and you're in the energy industry, so we know this goes on? Or how can you even begin to help a client think through that risk as far down the slippery slope as that may be?
Yeah, I think if we go down this slope fully, if this is not an outlier, if this what I consider to be extraordinary decision to charge Smartmatic under these extremely charged sort of political circumstances becomes more the norm, then the scenario you just laid out might become reality. I think that's a scary thing. Should scare everyone, whether you're in this business or not. We should all care about that. Again, all we have right now is the Smartmatic indictment, and there's always the chance there's circumstances behind the scenes that we're not aware of and are jumping to the wrong conclusions. But to your question, I think part of the discussion with clients often is, especially when we've discovered some sort of misconduct or something that could potentially be misconduct, and there's discussions about what do we do about this? Even outside of the context of, are we to the point where we're going to discuss voluntary disclosure? How do we assess the risk associated with this conduct? Certainly in some industries where you have a very competitive environment, and for certain, some of your competitors are close to the administration, maybe they're donors, maybe they're not, maybe you all are donors, frankly, and in which case maybe it doesn't matter. One of the things you're probably going to think about is, hey, look, if our competitor finds out about this conduct, even if it's not, we've determined that there's no basis or factual basis, or it's not a violation of the law. We have to think about the fact that they might raise it to the powers that be and try to pressure some sort of action against our company. I think really the only thing you can do on the receiving end of that is take all the appropriate steps that you probably should do anyway. If you're going to do an internal investigation, make sure you do it thoroughly and make sure it's buttoned up, that you've taken appropriate remedial action to the extent that any is required. I've worked with plenty of companies where we have done an investigation, determined there was no violation of the law, but that remedial action was nonetheless appropriate in terms of closing some internal control gaps or taking employment action against certain employees for certain internal policy violations. Doing all those steps so you're prepared in case you arrive at a situation where a competitor has sort of pointed the finger at you.
About the only thing I can firmly conclude is your job just got a lot more difficult.
Yeah, the funny thing is, I was feeling in June, at the beginning of the summer, that there was a real effort to inject some certainty into this analysis. Especially given everything that was said about the desire to make it easier for companies to comply, the desire to avoid unduly burdening companies, whether with overbroad investigations, in the context of a compliance monitor, all of these decisions. Even part of the criteria or considerations for bringing an investigation asks prosecutors to think about the potential impact on the company's business for the investigation itself, not just the penalties. Really thought that we were at a place where it was going to be a little bit easier to predict how the Department of Justice was going to approach companies. Again, like I said before, not certainty, but a little more predictability. This certainly throws a wrench in it. I am the optimist in me. Tom is hopeful that this is just a strange outlier of a case, right? Maybe there's facts that we don't know of stuff happening behind the scenes. Maybe it is just politically charged, but it's sort of a one-off decision where politics got and we don't have to deal with this. And 3 years from now, we kind of look back on this as an anomaly. But certainly in the short term, as we're working through these issues with clients, it's something we have to think about.
And the optimism you felt in June, actually, I had a little bit more because I thought we'd seen several instances where the Department of Justice put that policy into action. And I was beginning to sense that they had a real commitment to that policy. But like I said, I think the job for people like you just got a lot more difficult.
I like the challenge, although I prefer not to have it in this exact context.
Mike, thanks so much, and I look forward to continuing our conversations.
Thanks for having me, Tom.